Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to the Employee Survival Guide, produced by employment attorney Mark Carey.
Yeah, we've got a really interesting one today.
We do. And, usually when we talk about a medical diagnosis or some kind of physical limitation, there's this comforting expectation of precision.
Right, like it's a science.
Exactly. It feels almost like engineering. You break your arm, you go to the hospital, and the x-ray shows that jagged white line right against the black background.
And the doctor just points to it and says, there it is. That's the problem.
Right. It is entirely binary. The bone is broken or the bone is intact. The visual is clean. The diagnosis is objective.
And the path forward is pretty universally agreed upon. You put it in a cast.
Right. We are inherently drawn to that kind of clarity, I think.
Oh, absolutely. Mm-hmm. We want our struggles to be visible and neatly categorized.
But then you step out of the hospital, right? And you step into the world of employment law.
Yeah, that's where things get messy.
Really messy. Specifically, you step into this realm of physical trauma, chronic pain, and workplace accommodations. And suddenly, that pristine x-ray machine is just completely shattered.
Yeah, you're no longer dealing with simple binaries.
Not at all. We're looking at a diagnostic and legal landscape that is incredibly murky. It's this space where your physical reality clashes directly with your employer's corporate reality.
It is the absolute definition of diagnostic muddy waters.
Right.
I mean, the murkiness isn't just in the medical science of how pain affects a human body on a Tuesday versus a Thursday.
Right.
That murkiness is intentionally woven right into the fabric of the legal system itself.
Yeah, it's built in.
Exactly. So today, we're examining a fascinating legal battle. It's Raymond v. 1199 SEIU National Benefit Fund.
We're basically stripping away the complex legal jargon to expose the hidden machinery of workplace accommodations.
Right. What's fascinating here is that we are looking at appellate court footnotes and actual exhibits that reveal exactly how employees can win and lose their rights in court.
It's the high-stakes game of federal litigation. But before we look at the map that tore this case open, before we get into the courtroom drama, we need to hand you 4 keys to surviving your own workplace.
Yeah. These are essential.
We have 4 fundamental takeaways for you, the employee listening right now. These are the absolute pillars of what we're unpacking today.
And these are principles that apply whether you work in a warehouse, an office tower, or, out in the field.
So takeaway number 1, your employer does not have the final say on your job description.
Which is huge because people think the handbook is law.
Right. We have this ingrained habit of treating an HR handbook or a job posting like a sacred text. If the employer wrote it down, we assume it's an immovable law of nature.
But while courts do give employers deference on what an essential job function is, a jury ultimately gets to decide the facts.
Exactly. Takeaway number 2 is about how you prove that reality. Visual evidence is your absolute best friend.
Oh, yeah. You'll see today how a massive organization denies an undeniable physical reality.
And when employers deny obvious realities like commute time subjective evidence, like maps, can single-handedly save your case.
It strips away their ability to manipulate the narrative.
Takeaway number 3 is a harsh reality check, honestly. The burden of proof is on you if you ask for a job transfer.
Yeah, that one catches a lot of people off guard.
It does. If you request reassignment as a medical accommodation, you must legally prove an actual vacancy existed at that time.
You can't just say, this job hurts, put me somewhere else.
Right. They won't invent a job for you.
No, they won't.
And finally, takeaway number 4, your voice is actual evidence.
Which is probably the most empowering piece of knowledge you can have.
Absolutely. Courts cannot simply ignore your testimony when deciding if your case should go to trial. Your word alone can defeat an employer's motion for summary judgment.
Yeah, your voice has immense legal weight.
Okay, let's unpack this physical reality of the plaintiff's job, because this is where a seemingly simple commute becomes a federal lawsuit.
Yeah, we're talking about Sean Raymond.
Right. Sean Raymond worked as an outreach coordinator for the 1199 SEIU National Benefit Fund, which is a mouthful.
Yeah, let's just call them the MBF.
Good call. So Raymond's home base is Elmont, New York, specifically 1131 237th Street.
To really grasp this dispute, you have to understand the geography. An outreach coordinator is a field agent.
Right, they don't sit in a cubicle.
Exactly. They travel to different union shops, healthcare locations, client sites. It's a highly mobile job.
And the NBF divided its jurisdiction into multiple geographic zones. There are at least 10 different zones an outreach coordinator could be assigned to.
Areas A through J.
Right. And Raymond lives in Elmont, which is this very specific border town where the dense urban grid of Queens bleeds into the sprawling suburbs of Long Island.
And that starting point is the epicenter of this entire conflict. It's not about medical terminology, it's about miles on a highway.
Yeah. The court documentation includes this incredible visual exhibit. It's a map comparing two of these specific assignment zones, Area I and Area J.
And it is a striking map.
Let me describe it. Raymond's house in Elmont is marked with a black house icon. It's the anchor. Then you look at the shops assigned to Area I.
The red pins.
Right. Area I has red pins, and they are scattered far out across eastern Long Island. We're talking deep into Suffolk County.
Which means significant prolonged highway travel.
Yeah, getting on the Long Island Expressway and just driving for miles and miles, and you have to drive a massive distance just to reach the very first shop from his house.
But then you look at Area J.
Area J is marked with blue pins. And these blue pins are clustered so tightly together, they're heavily concentrated right in the western Long Island, Queens, and Brooklyn area.
They're virtually in his backyard compared to the red pin.
Exactly. If you look at this map, it takes maybe 2 seconds to realize that covering Area J requires a fraction of the driving time that Area I requires. The visual data is overwhelming.
Which makes what happens next completely baffling.
Oh, this part drove me crazy.
That's right. If you look at footnote 2, it highlights a critical piece of litigation behavior. The employer, the NBF, and a key figure named Saucy never actually admitted that Area J requires far shorter drives than Area I.
I mean, I have to stop you there, because why would an employer refuse to admit something that is visually obvious to anyone looking at a map?
Because it's a lawsuit.
But it's like looking at a blue sky and refusing to admit it's not green. The pins are physically closer. How do corporate lawyers justify just saying, we don't admit that?
Well, it sounds absurd to a normal person, but this is a classic legal strategy. It's the make them prove it defense.
So they don't actually believe Area I is closer.
Of course not. But think about the legal chess game. If the NBF admits, yes, Area J is a much shorter drive, they've just handed the employee a massive advantage.
They've basically conceded a core part of his accommodation request.
Exactly. They make his path to victory cheaper and faster. So instead, they deny it. They force the plaintiff to spend time, money, and emotional energy proving something that should just be common sense.
That is just institutional gaslighting.
It absolutely is. It's an attrition tactic. And that's exactly why having objective, undeniable exhibits like this specific map is so crucial.
Because arguing with them gets you nowhere.
Right. The appellate judges looked at the map and essentially wrote, even though the employer never admitted it, the map makes the fact completely clear.
The court just bypassed their denial entirely.
Yeah, the map stripped away their ability to manipulate the story. That's why visual evidence is your best friend when an employer denies basic reality.
So true. So this dispute over physical distance on the map directly causes the central legal conflict of the case.
Yeah, it forces the question, does the job fundamentally require long, uninterrupted driving?
Which transitions us from geography to the legal definition of an essential function.
Right. And to understand that, we have to break down footnote 4. This explains the Equal Employment Opportunity Commission, or EEOC, regulations.
Specifically, 29 CFR Section 1630.2.
Exactly. The EEOC clearly defines the stark difference between fundamental job duties and marginal functions.
So fundamental duties are the core reason the job exists.
Yes. And marginal functions are the stuff you do, but they aren't the main purpose of the role.
Like, if I'm hired as a graphic designer, my fundamental duty is designing things on my computer.
Right.
But if the office asks me to water the lobby plants every Friday, that's a marginal function. If I break my leg and can't walk to the lobby, I can still be a graphic designer.
Exactly. But the real fight isn't the regulation itself. It's how courts interpret it. There's this massive legal tug of war between two different cases.
Here's where it gets really interesting.
Because one side heavily favors the employer. It's the D'Amico case. Under D'Amico, courts must give considerable deference to an employer's judgment about what is essential.
So if the employer's HR department writes, must drive 3 hours a day in the handbook, the court just defers to them.
Historically, yes. Employers waive their handbooks and say, we wrote it down so it's essential.
But the ultimate trump card actually belongs to the jury.
Yes, it does.
Under the McMillan case, determining essential functions is a quintessential fact-bound inquiry best suited for the jury.
Which is a fancy way of saying regular people get to look at the mess of facts and decide the truth.
Exactly. It's like a job description that says, must be able to lift 50 pounds daily.
Oh, you see that all the time on office job postings.
All the time. But then the employee proves they actually only ever lift 10-pound folders. There isn't even a 50-pound object in the office.
Right.
Just because the employer wrote it down doesn't make it the essential reality of the daily work. The jury gets to look past the paperwork.
And if we look at footnote 6, we see how the appellate court applied this to Raymond. Because the jury gets the final say, the appellate court makes a reasonable inference at this stage.
Right. They cite the Bay v. City of New York case for that.
Yes. They infer that Raymond's essential functions do not require driving for more than 30 minutes uninterrupted.
30 minutes uninterrupted. So they're refusing to just rubber stamp the NBF's claim that long, arduous driving is a core requirement.
Exactly. The map proves Area J requires less driving, and the jury gets to decide if that less driving is acceptable for the job. It's a massive win for the employee.
But getting to that jury isn't easy.
No, it is not.
Which brings us to the procedural gauntlet. We have to talk about summary judgment because this is how facts are judged before a jury ever sees them.
This is the most critical phase. Long before a trial, the employer will almost always file a motion for summary judgment to try and kill the case.
And the judge makes this decision based entirely on the summary judgment record, right? We see this in footnote 7.
Yes. The summary judgment record is a strictly defined, closed universe of facts.
Let me use an analogy here because this is crucial. Think of summary judgment like the ingredients you declare before a cooking competition.
Okay, I like that.
You bring your basket to the judges. You say, these are the ingredients I'm cooking with. You go through the whole competition. You can't suddenly pull a hidden spice out of your pocket during the final tasting and say it was part of the recipe all along.
Right. The judges would disqualify the spice.
Exactly. If it wasn't in the initial record you presented, the appellate court won't credit it.
And that's exactly what happened here with the NBF.
They messed up their ingredients.
They really did. The employer brought evidence to a later trial to cast doubt on Raymond's physical limitations. But that evidence was not in the summary judgment record. So the appellate court essentially pretended it didn't exist.
Yeah. They're just like, sorry, you didn't declare the spice.
Exactly. And the court gave instructions on remand, meaning sending it back to the lower court, that the district court has to decide whether to generously reopen the record to let them add it or just proceed straight to a failure to accommodate trial.
The procedural rules are just merciless.
They are. But while the employer made a mistake with their evidence, the lower district court actually made a massive error regarding the employee's evidence.
This is footnote 8, and this is so empowering for the listener.
It really is.
The lower district court judge acknowledged Sean Raymond's own sworn testimony about his limitations and abilities, but they didn't credit it.
The judge basically read the testimony and said, I don't believe it's enough.
Which is an error. Under the McMillan precedent, a plaintiff's testimony alone is enough to defeat an employer's motion for summary judgment.
As long as they're stating that their proposed accommodation would allow them to perform essential functions.
Right. I want everyone listening to hear this. Your voice has immense legal weight. You don't always need a team of experts. Your word, under oath, saying, I can do this job with this accommodation, is actual evidence.
It forces the court to let a jury decide. It's incredibly powerful.
It really gives you a fighting chance. But there are boundaries to the ADA, and Raymond hit one of them hard.
Yeah, he made a critical misstep when he tried a backup plan.
Let's talk about the failed backup plan. We're moving from his arguments about his current job in Area J to him asking for a completely different job.
If we look at footnote 9, Raymond didn't just ask to stay in Area J.
Right. He actually emailed a request to be moved to a different position altogether, one that required less extended driving.
Which sounds reasonable to a normal person.
Totally. People ask for internal transfers all the time, but legally asking for a transfer as a medical accommodation is incredibly risky.
Because of the burden of the vacancy. The court cites the Jackin case here. The law says the employee bears the burden of proving that such a vacancy actually existed.
So Raymond couldn't just say, find me a desk job.
No. He had to legally prove that a specific funded desk job was open and vacant at that exact time.
And he couldn't do that.
He couldn't identify any open positions. So the court said his request was not plausible on its face.
It just feels so harsh. If you're out on medical leave, locked out of the company intranet, how are you supposed to know what jobs are vacant?
It's a huge burden. But the courts are very strict about it. The ADA doesn't force a company to invent a job for you.
That brings up a wild twist in footnote 9 regarding this transfer request.
Oh, the interactive process disappearance.
Yes. So in his written briefs, Raymond argued he should win because the MBF flat out refused to engage in the interactive process, which is that mandated back and forth conversation about accommodations. He was hanging a lot on the fact that they stonewalled him.
But then at oral argument, this is at timestamp 1.10 to 1.35 of the actual recording, his own counsel disclaimed the interactive process claim.
They completely abandoned it.
Why on earth would a lawyer completely abandon a major argument while standing right in front of the judges? I mean, they wrote pages about it in the brief.
It comes down to the intense pressure of oral arguments and the strict rules of appellate review. If we look at footnote 10.
Okay, what does it say?
It points out two things. First, it cites United States v. Sturkage, which establishes that the Second Circuit is strictly bound by its own precedent unless it's overturned en banc or by the Supreme Court.
So they can't just change their minds to be nice. They are locked in.
Completely locked in. And second, the footnote notes that Judge Loretta A. Preska was sitting by designation on this panel.
Meaning she's a visiting lower court judge.
Right. A visiting judge is absolutely not going to defy circuit precedent.
So the lawyer is standing there looking at a panel that legally cannot bend the rules for him. Exactly. And the strict precedent in the Second Circuit is that failing to engage in the interactive process doesn't give you an automatic win if there was no reasonable accommodation available anyway.
Oh, because Raymond couldn't prove a vacancy existed, there was no accommodation possible.
Right. You can't sue them for failing to talk about a job that didn't exist.
So the lawyer realized, if I push this doomed argument, I'm going to lose all my credibility with these judges.
Exactly. He dropped the weak claim to save his credibility for the stronger claims, like the map and the 30-minute driving limit.
It is a high-wire act. You really have to know the legal machinery.
You do.
Well, we have covered so much ground today as we deep dive into the source material. I mean, from geography to appellate strategy.
It's a lot to process.
It is. So let's summarize the 4 takeaways we discussed earlier so you, the listener, can carry these with you.
Number 1, juries, not just employers, decide what your essential job duties really are. Don't let an HR document rewrite reality.
Number 2, bring receipts and visual evidence. Maps and data cut right through employer denials.
Number 3, if you ask for a new position for medical reasons, you must prove the job is actually vacant. The burden is on you.
And number 4, never underestimate your own testimony. Your word is powerful legal evidence at the summary judgment phase.
If we connect this to the bigger picture, I'd leave you with this to mull over. Think about your own job description right now.
Yeah.
How many of the tasks you do every day are truly essential functions, and how many are just marginal functions that have been piled on by tradition or convenience?
That's a great question.
If you ever need an accommodation, knowing the invisible boundary between those two categories might just be the most important piece of knowledge you have.
Absolutely. You have to know the true geography of your own job. Thank you for listening, and we'll see you next time.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.